In today's video, we're examining a question that many Americans never seriously consider until it's too late. Is it actually possible to lose United States citizenship? For most people, the idea seems almost unthinkable. Once you're a citizen, that status feels permanent. You carry a U.S. passport. You vote in elections. You're protected by the Constitution. The assumption is that citizenship, once granted, is forever a status that cannot be undone. Here on at American Visa Update, we focus on the legal realities behind immigration, borders, and citizenship. And the reality is this: U.S. citizenship is one of the most powerful legal statuses in the world, but it is not completely immune from loss. There are legal mechanisms, government processes, and real cases that show citizenship can be taken away under certain circumstances. Some of those circumstances involve a conscious choice. Others do not. And in some situations, the process can move far more quickly than most people expect. To understand how citizenship can be lost, it's essential to understand how U.S. law defines citizenship in the first place. Broadly speaking, there are two main categories of U.S. citizens. The first category includes citizens by birth. These are individuals born on U.S. soil, including U.S. territories such as Puerto Rico, Guam, and the U.S. Virgin Islands, as well as certain individuals born abroad to at least one U.S. citizen parent who meets specific residency requirements. The second category includes naturalized citizens, people who were not born U.S. citizens but later obtained citizenship through the immigration and naturalization process after years of lawful residence, background checks, interviews, and sworn oaths. On paper, both groups enjoy the same constitutional rights. They can vote in federal elections. They can hold public office. They can obtain a U.S. passport. They're entitled to due process and equal protection under the law. But when it comes to the question of losing citizenship, the government treats these two groups very differently, and that distinction is critical. For citizens by birth, the 14th Amendment provides exceptionally strong protection. In almost all cases, their citizenship is considered permanent and irrevocable. Courts have repeatedly ruled that birthright citizenship cannot be stripped arbitrarily or as a punishment. For naturalized citizens, however, citizenship is the result of a legal grant. And because it is the product of a legal process, it can be legally undone if the government later proves that the process itself was compromised or based on false information. The most direct and least controversial way to lose U.S. citizenship is voluntary renunciation. This is not something that can be done casually, emotionally, or informally. It is a formal legal act governed by federal statute. To renounce citizenship, an individual must appear in person at a U.S. embassy or consulate outside the United States. They must sign an official oath of renunciation and explicitly acknowledge that they fully understand the consequences of their decision. There is also a significant government fee, which in recent years has exceeded $2,000. Once citizenship is renounced, the consequences are permanent and immediate. The individual loses their U.S. passport. They lose the right to vote in U.S. elections. They lose access to federal benefits tied to citizenship. From an immigration standpoint, they become a foreign national. If they later wish to return to the United States, they must apply for a visa or other lawful entry authorization, just like any other non-citizen, and approval is not guaranteed. Each year, thousands of Americans voluntarily renounce their citizenship. Many live permanently overseas and choose to renounce for tax reasons, as the United States is one of the few countries in the world that taxes citizens based on citizenship rather than residency. Others renounce for personal, political, or lifestyle reasons, especially when they have fully committed to another country and no longer maintain meaningful ties to the United States. Regardless of the motivation, once the renunciation process is complete, there is no legal mechanism to reverse it. What surprises most people is that citizenship can also be taken away against a person's will. This process is known as denaturalization. While far less common than voluntary renunciation, denaturalization is real, active, and aggressively pursued by the U.S. government in certain cases. Denaturalization occurs when the government determines that a person should never have been granted citizenship in the first place. The most common basis for denaturalization is fraud or willful misrepresentation during the naturalization process. This can include failing to disclose a criminal history, lying about identity or biographical information, concealing involvement in violent acts, hiding service in foreign military or paramilitary groups, or misrepresenting political, ideological, or organizational affiliations. One of the most significant aspects of denaturalization law is that there is no statute of limitations. It does not matter how much time has passed since citizenship was granted. A person may have lived in the United States for decades, built a family, established a career, paid taxes, and integrated fully into American society. If the government later uncovers evidence that citizenship was obtained through fraud, it can still initiate denaturalization proceedings. This is not hypothetical or theoretical. There are documented cases in which individuals lived quietly in the United States for many years before their past was uncovered. In some cases, individuals were denaturalized after evidence emerged showing participation in war crimes during foreign conflicts that had been intentionally concealed during the immigration process. In other cases, former Nazi concentration camp guards were stripped of citizenship and deported decades after entering the United States, once historical records, witness testimony, and international investigations confirmed their involvement. These cases demonstrate just how far back the government can and does look. Denaturalization is not limited to recent immigrants or recent conduct. It is based entirely on whether the original grant of citizenship was lawful and truthful at the time it was given. Fraud is not the only factor that can trigger denaturalization. Associations can also matter. U.S. law allows the government to re-examine citizenship if, within a certain period after naturalization, an individual becomes affiliated with organizations that advocate the violent overthrow of the U.S. government, serves in a foreign military hostile to the United States, or takes a significant position in a foreign government without proper authorization. Even without direct involvement in violence, these associations can raise serious legal questions about whether the individual misrepresented their intentions or loyalties during the naturalization process. In these cases, the government's argument is often not that the later conduct itself automatically strips citizenship, but that the conduct reveals earlier deception when citizenship was granted. Dual citizenship is another area where confusion is widespread. In many cases, dual citizenship is legally permitted. Millions of Americans lawfully hold U.S. citizenship alongside citizenship from another country without issue. However, intent remains critical. If a person acquires foreign citizenship with the intent to relinquish U.S. citizenship, or takes an oath that explicitly renounces allegiance to the United States, that intent can place their citizenship at risk. Similarly, taking a high-ranking position in a foreign government, particularly one whose interests conflict with those of the United States, can trigger legal scrutiny. These are not abstract concerns. They are specific legal factors that courts and government agencies analyze when evaluating citizenship status. The rarest and most extreme scenario involves treason or armed rebellion. If a person commits treason against the United States, participates in armed rebellion, or acts as an agent of an enemy government, loss of citizenship may occur alongside criminal prosecution. These cases are extraordinarily rare, but the legal framework exists and has been applied in limited historical circumstances. Any loss of citizenship in this context follows conviction in federal court and intense judicial review. Many Americans are unaware that the Department of Justice maintains a specialized denaturalization unit within its civil division. This unit works closely with the Department of Homeland Security and immigration authorities. Using modern investigative tools, including biometric databases, digitized immigration files, international records, and advanced data analysis, the government reviews cases that may involve fraud, even if naturalization occurred decades earlier. When potential fraud is identified, the process is formal and legal. A civil case is filed in federal court. The individual has the right to legal representation, the right to present evidence, and the right to challenge the government's claims. The burden of proof is high, and the government must clearly demonstrate that citizenship was obtained unlawfully. But if the government meets that burden, The consequences are severe and irreversible. Citizenship is revoked. Passports are canceled. Voting rights are lost. The individual becomes subject to removal from the United States. In many cases, denaturalization is followed by deportation proceedings, particularly if the individual has no other lawful immigration status. For people born in the United States, citizenship is almost always secure. The primary exception involves fraudulent birth records, such as falsified hospital documentation, false claims of parentage, or organized birth fraud schemes. These cases are extremely rare and difficult to prove, but they do exist and have been pursued in limited circumstances involving large-scale fraud operations. Across all of these scenarios, one theme remains consistent. Citizenship loss is not arbitrary. It is tied to intent, deception, fraud, or voluntary surrender. The government cannot simply strip citizenship because of political disagreement, unpopular opinions, or lawful expression. The legal standards are high, and the process requires courts, evidence, and due process protections. Still, the existence of these mechanisms matters. U.S. citizenship carries extraordinary rights and protections, but it also carries legal responsibilities. Understanding how citizenship works, how it can be lost, and how the law is applied is essential for citizens and immigrants alike. Citizenship is not just a document or a passport. It is a legal status governed by complex laws, enforced by powerful institutions, and shaped by real cases with real consequences. And in the rare but serious situations where those laws are violated, the results can permanently alter a person's life. This has been at American Visa Update, providing clear, factual insight into U.S. immigration and citizenship law, and the legal systems that continue to shape lives across the country.